So in the last video, we talked about bail, bringing you understanding that release of person on bail either by law enforcement agents or the court is not a conclusion that he has been set free. No. So today we're going to build on that discussion. We're going to talk about bail in capital offenses. The position of the law is that if a person is charged with a capital offense, he will not be granted bail. Capital offenses are offenses that carry death sentence or life imprisonment upon being convicted by the court of competent jurisdiction. Now, most likely the mindset of the draft writer is that if a person knows the level of punishment that will come upon him upon conviction by the court, he is likely to do everything possible to avoid the trial once he is released on bail, which is to say the person may take to his heel and never be found again in an attempt to escape trial. But then there are some exceptional circumstances that will assist the court to grant you bail even if you are charged with capital offenses. Number one is on the ground of ill health. However, the position of the law is very clear. Not just every ill health, but you must have a proof, you must satisfy the court that the condition of your ailment is such that the detention facility you are incarcerated in does not have the medical facility to attend to your health condition. You will be granted bail in circumstances like this. But I know the position is most times you will still be under supervision. I've had a situation where I visited a hospital and there was about 2 policemen guarding one particular room, and being a lawyer, I got the understanding for myself that most likely this person is in detention, but based on health ground has been granted bail or has been taken to hospital. Another circumstance is that where there is an inordinate delay in the prosecution of your case, there are situations where you will see that a person is charged to court, is arraigned, and then is remanded in custody, and from that time, nothing happens. This reminds me of a person I met in prison during my NYSC. We met this guy in the prison, and he told me the last time he was in court was in the past 5 years. Brought out his charges. The charges I can't even explain. You will hardly be able to read what is there. He has been lying in prison facility for 5 years without being taken to court. Now, these are situations where if you are able to get a lawyer to approach the court, you will be able to be granted bail based on the condition that there is an inordinate delay in the prosecution of your case. Now, we have a very serious issue on this personally. There is no provision to compensate a victim where a person is wrongly charged with a capital offense. And sometimes the trial for this will take 3, 4, 5, 6, 7 years. And at the end of the day, the person will be discharged and acquitted by the court. In the circumstance of some uniformed men, if you are charged with allegation of any offense, they go through orderly room trial. They will first be dismissed and then handed over for prosecution. And then you realize if at the end of the day they are discharged and acquitted, you come back, you approach the service, you approach the National Industrial Court for them to be reinstated, have their salaries and promotion allowances or whatever reimbursed. But what happens to a common civilian like you and I, that maybe you don't have an employer, it's not your employer that dismisses you, and then on a slight opportunity, someone doesn't like you, or mistaken identity, you are charged with a capital offense. The police refuse to grant you bail because your charge against you is not bailable. You are arraigned before the court and the court did not grant you bail because the offense you are charged with is ordinarily not bailable. And then you stayed for 5 years, 7 years in detention, and then at the conclusion of the trial, you are discharged and acquitted. There is need to make provisions for compensation of such persons. They must have gone through a lot of trauma, stigma, absence from the family, absence from job, and then you come out at zero. What will be the provision for your compensation? That for now we don't have. And that is why we are making a call on civil society, we are making a call to law enforcement agencies, we're making a call to our legislators, to all meaningful Nigerians, to see to it that as long as the right of an accused person is guaranteed by the Constitution, there should also be provision for persons who are wrongly accused. We know that once there's a petition against you or a complaint and then the police investigate into the matter and you are leveled with a capital offense and you are charged, the provision that you will not be granted bail applies. I am also of the opinion that the power of the police to investigate, to conclude on the investigation and decide on what to charge you, what offense to charge you with, should also be looked into. Because a lot of innocent Nigerians, as we all know, sometimes there is a difference between facts and the truth, have suffered this wrongly charged. You are charged with an offense, not granted bail, and then after a whole period of years, a person at the end of the trial is discharged and acquitted, and he comes out zero, not knowing where to start either from his left or his right. So please, this is a call for us to look into this issue again and possibly suggest better measures that can be put in place for a person that is charged even with a capital offense to be granted bail pending the conclusion of the trial against him. I remain Ishaku Joseph, your favorite lawyer. Do well to subscribe to our channel, share, like, drop your comments that we will do well to respond to. Thank you very much, and we'll see you in our next video.